have summarized the Indian Arbitration and Conciliation Act, like how it was. I mean, the amendment, how it was evolved from the first act. The first act was enacted in 25th January 1996. Then the first amendment to the act was in 2015, which was 23rd October, I believe. Then the second amendment to the act was in 2019, and then the current amendment is in 2021, which I believe in the month of March. Okay, so let us begin with this session by just talking about the key objective of Indian Arbitration Act, because it is very important to remind ourselves the key objective of the act, because there are many things happening around us. There is a New York Convention and unsettled model law, and many things happening around the world. So the amendment is to incorporate those changes in the act. That is very important, because the objective, it says the key objective of Indian Arbitration Act 1996 is to make provision for an arbitral procedure that is fair, efficient, and capable of meeting the needs of the specific arbitration, and to minimize the supervisory role of the courts. Okay, the remaining is self-explanatory. You can go through it. So we must understand the key objective, and this is the reason there is an amendment we are encountering. So next one. So the next slide is just relevant to this today, section 29A, which is time limit for arbitral award. This is the amendment which we see it through the 2015 amendment. So the 29A, which says section 29A of 2015 amendment, which says the award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23. The second part of same provision says, provided that the award in the matter of international commercial arbitration may be made as expeditiously as possible, and endeavor may be made to dispose of the matter within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23. So there are two parts comes with this provision. The first part, clearly it says the award in matters other than international commercial arbitration. So it is very clear the award in matters deal with other than international commercial arbitration, right? So it can be domestic arbitration. So the arbitration shall be made by the arbitral tribunal within a period of 12 months. So there is a clear-cut timeline given by the act to follow 12 months timeline. Okay, which again says from the date of completion of pleadings under subsection 4 of 23. So what is subsection 4 of 23? Which says the third point, the parties may by I have kept in the next slide that the subsection 4 of 23, which says the statement of claim and defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, received notice. So what it clearly says, the first part and the subsection 4 of 23, there is a 6-month period for pleadings, and then thereafter there is a 12-month period, which is for specifically for rendering award, which is very clear. It deals with the arbitration other than international commercial arbitration. So when we look at the second part of this 29A, it says, provided that award in the matter of international commercial arbitration may be made as expeditiously as possible, and endeavor may be made to dispose of the matter within a period of 12 months from the date of completion of pleadings. So we have to be very careful in this part, because when we read the first part, it gives you a definitive timeline for rendering award, 12 months period. But when we read here, it says the matter of international commercial arbitration may be made as expeditiously as possible and endeavor may be made. So dispose of the matter within a period of 12 months. Okay, although a period of 12 months is indicated in this provision, it is not a definitive period. That's what my understanding. Because when you compare these two provisions, the second part clearly says international commercial arbitration may be made as expeditiously as possible and endeavor may be made. Okay, so my understanding is it is clearly left at the discretion of parties and arbitral tribunal to decide the timeline required for the arbitration, dispute in arbitration, whatever the specific arbitration. So that's what my understanding. Again, the subsection 4 of section 23, which limits 6-month period, which is consistent for both arbitration other than international commercial arbitration and international commercial arbitration. So the period 12 months, which is not very definitive to the international commercial arbitration, which is at the discretion of parties in the tribunal. That is what my understanding. At the end of the session, we can discuss more about this. Okay, then this 12 months and 12 months given for the rendering arbitral award can be extended further period of 6 months, not exceeding 6 months, with the consent of parties. Okay, in this slide, I have given a summary of what we went through now. So 29A effectively as per subsection 4 of section 23 and section 29A, the statutory timeline for arbitration proceedings shall be 6 plus 12, which equals 18 months. This is applicable for arbitration other than international commercial arbitration. The timeline of 12 months, which is given specifically given for rendering the award, can be further extended to a maximum of 6 months with the consent of parties. Then the third bullet point, effectively as per subsection 4 of 23 and section 29A, the statutory timeline for international commercial arbitration shall be 6 plus 12 to be determined, I put, based on my understanding, so which equals 18 months tentatively. So the timeline of 12 months award period can be further extended to a maximum of 6 months. I have made some comparison how the amendments evolved from 1996 Act, and then the first amendment to the Act was 2015. In 2015, 29A was inserted with a title of Time Limit for Arbitral Award. Then with a provision of the award shall be made within a period of 12 months from the date the arbitral tribunal enters upon the reference. This was introduced in 2015 amendment. So it does not distinguish that the 12 month is for commercial, international commercial arbitration or domestic arbitration, which is a 12-month period applicable for arbitration proceedings. So there can be some issues later on when if the period 12 months is not adequate for international commercial arbitration, there may be some dispute arise between the parties in relation to this. Then arbitration amendment 2019 and 2021 we went through recently. So these are the two things which further substituted. The next slide, in 2015 amendment section 23, there was no provision for the extension, which is clearly given, substituted in, introduced in 2019 and 2021. The statement of claim and defense. Yes, it's correct. Yeah, which is introduced in 2019 and 21 for the pleadings period. Then 29.4 remains same, which was introduced in amendment 2015 for the 6-month extension, which is remaining in 2019 and 2021 as well. Okay, so we went through these developments. So we must understand the backgrounds of these amendments, because the act would not be, I mean, amended without any reasoning, right? There will be a reasoning to make some amendments. So the 20, I mean, the the Conciliation Act itself, it clearly says it the it is not telling the court to intervene in this matter. I mean, the time limit for the arbitral proceedings. Again, the court will only exercise its inherent function when there is an application from the parties to extend the timeline or rearrange the timeline, etc. So the court will not voluntarily intervene in setting out the timeline for the arbitration proceedings. The act also very clear. It does not say that the court should intervene, but it is exercising the inherent function, I mean authority, based on the application of the parties. So there are two cases in the past. Before the amendment, in the Indian arbitration regime has faced many difficulties, because some of the arbitration went beyond 10 years and 9 years, like. So this was the issue, and the main purpose of arbitration act is to, I mean, reduce the burden of court. But if the arbitration itself keep on proceeding like for 9 years, 10 years, then the subsequent involvement of court, it does not meet the very purpose. That is the reason. So the section of timeline has come in the arbitration act. There are two cases I found. The first one, it says the first one is Oman Refineries Limited versus Mrs. Montech Consultant Appeal number 702/2011, which in this case it was held. The courts have upheld prescribed timelines in contractual agreements and rendered decisions beyond the timelines as their law. Okay, so we can understand from the decision. So the timelines agreed within the contract must be respected by the tribunal. If at all any timelines goes beyond the prescribed timelines, which is not the good law. So the next case what I found is NPCC Limited versus JC Engineering Private Limited. Uh, in this case, there is a settled law that an arbitrator has no power to further extend the time beyond that which is fixed in the agreement without the consent of the parties to the dispute. In the absence of an extension, the mandate of a tribunal automatically terminates after the expiry of the fixed timeline. So it is very clear the arbitral tribunal has no power to extend the arbitral proceedings timeline without the consent of the parties. So these are the two criteria the court has made very clear in the past, which should be maintained in the arbitral proceedings. This is one of the key issue to introduce the timeline in the Arbitration Act. This is my understanding, because the court has made clear in the past these two things are to be, there is no lenience on these two aspects, because the parties' rights spelled out in the contract must be respected. The third case what I found is Jayesh Pandya and another versus Subtex India Limited and others. It was held that if there is a contractual term specifying a time limit in which the award must be rendered, then the arbitrator is the arbitrator duty is to bound to do so in that stipulated time. Otherwise, their mandate would be cancelled automatically, which is again in line with the previous case which we have seen. So again, I have I have made some chart here how this decision reached in this case, the J.S. Pandya case, how the decision reached by the Supreme Court, which again you guys can go. This is my own chart. I just Supreme Court had
Okay.
reached the decision. So the Supreme Court view was that parties' right must be respected. There is no, I mean, liberty at the arbitral tribunal to extend the proceedings at their discretion. Again, it should be at the with the consent of parties. That is what the Supreme Court